All right, everybody, we're back. You're free to go. Your favorite podcasts, and Mark and I, it's our favorite thing for us to do is to bring you our stories and share with the world our experiences in the criminal justice system. So thanks for being here, and as always, please remember to like, follow, and subscribe. And it's free to subscribe. It doesn't cost you a penny. So we look forward to seeing all the new subscribers online in the next 24 hours and beyond. Um, yeah, so Mark is in LA today. Good to see you out there, Mark. How's everything?
Everything's great. Good morning. Beautiful sunny day today,
Good.
and anxious to get started with our podcast.
Yeah, all right. Well, I know it's always funny that time change, only 3 hours difference, but it's already lunchtime for me. So let's do a podcast, and I think I'll take Eric, the engineer, today for lunch.
Oh,
All
good.
right, yeah. Okay, so I want to, we've done a couple episodes recently with starting with a little question that comes from our viewers or a client. I don't know if we'll do this every episode, but I had one that came up, so I want to do it again. And just as a reminder to everybody, if you've been in with us from the beginning or not, but you've gone back and watched from the beginning or our initial trailer, Mark and I are doing this because we just love sharing our stories with the world. We go out with friends and family, and they always want to hear about our cases, and so that's why we started this whole podcast. And but I have seen, as Mark has, we get calls now because there's so many people following us, and it's gone viral to some extent. That we'll get calls at the firm for clients and business and so forth. And one I got the other day called because they said that they got a subpoena for some records or for a statement about a friend of theirs, and they called me to say, hey, and am I allowed to call my friend and tell him that it looks like there's something going on here with law enforcement? I don't want to get myself in trouble, but kind of want to give my friend the heads up. So I thought, well, I've actually had that question come up before. So this was arose kind of out of the podcast, by someone who listens to it and called to see if they need to hire an attorney. They said to me, "Do I need an attorney to respond to this?" and so forth. And then I realized it's a question others have asked me over the years. I'm sure you have too, Mark. And I know officers will say, hey, please don't tell anyone, that we came here and we're questioning you and so forth. But the real question is, do you have is it legally binding that you're not allowed to repeat it? The other thing that comes up in this same scenario is if a bank gets a subpoena for bank records, which could be an indication that there's a white collar fraud criminal investigation going on of some sort, some type of business crime investigation, and the legal authority, the investigative authority, is looking at bank records. The bank is often the first to know because they get a subpoena for bank account records. Is the bank allowed to call? Let's say they get records for records for John Doe's bank account. Are they allowed to call John Doe, who's one of their good clients and customers of the bank, and say, "Hey, Mr. Doe, want to let you know you might want to hire a lawyer because you're under investigation." So, Mark, what's your what do you say? When people ask you that, and your position on whether you can tell someone if you got subpoenaed for records?
Well, first of all, if you're an individual and you get, or even a small company, you get a subpoena for records um, from a grand jury, you are not necessarily prohibited from disclosing that to somebody. What the limitation is if the government can prove that you did so with the intent to obstruct justice. And that's probably a high standard for the government to meet. But if you are intending to obstruct justice by disclosing something to somebody and then they turn around and use that information to either hide assets or abscond from the jurisdiction, and potentially you could have a problem. It's more of a practical situation. Government agents, FBI agents, prosecutors will often, if not universally, tell the individual or small business owner that, look, we'd appreciate, or we don't want you telling so and so about the subpoena. Um, then you're going to abide by it because, first of all, you don't necessarily know that you have the power to not follow their instruction. And secondarily, you don't just want to run the risk of having somebody become your enemy who's got that kind of power. So it rarely comes up that somebody gets prosecuted for it. And as I said, it would take a lot for the government to have to prove that you actually disclosed this because you were intending to obstruct their investigation, knowing that the person was going to use this information to frustrate the government's investigation, hide assets, or become a fugitive. So, generally speaking, it rarely comes up, but I would tell somebody, look, just be practical about it. If it's a very close friend or family member, then, do what you want to do, but just keep in mind, you got to be careful. And if it's somebody that you don't care about, my practical advice would be follow the government's request.
Yeah.
Look, a lot of times they request it just as a matter of course, knowing that you're probably going to turn that information over anyway. Now, when it comes to banks, financial institutions are mandated by law. There are two situations where they are prohibited from notifying customers of a grand jury subpoena is when there's a court order, delaying notification, and the second is where the records are being subpoenaed to investigate crimes against the financial institution. In those instances, banks are prevented. Now, there is the Right to Privacy Act that banks have to follow. And if you remember, when you opened a bank account, they probably had you in these days electronically sign something.
Right.
And behind that electronic signature is 70 or more pages
Yep.
of your customer service agreement,
And lawyers
which
never
probably
read those. Well, lawyers are the
nobody ever
worst. We
reads
just
that.
sign. We
So
just
you can
sign. Yeah.
read that.
Well,
I always,
by the way, if we do read it and want to make a comment or edit, they're not going to agree to the edit anyway. So it's a waste
that's
of time.
interesting because we always joke and I always say when somebody hands me something, I immediately sign it. They
Right.
said, "Don't you want to read it?" I said, "What for? Can I change it?"
Yeah.
And the joke is, how can you tell someone's a law student when they go in to buy a car and there's this long form leasing agreement and they say, "Well, I want to change this, I want to change this, I want to
Right.
change that."
Yep.
I mean, you can't change these things.
Yeah, I remember
Uh,
a classmate of mine in law school got a really bad haircut, and they asked the professor, could they sue the hairdresser?
yeah,
That's
right.
when you're in law school, you're
You're in law
lawyering,
school, you think.
you're lawyering all the time. Right, right.
Right.
So
But in any event, these customer service agreements usually protect the bank and provide notice of that the bank's not going to tell you of certain things. In this case, subpoenas. But so my bottom line is, I tell clients when they get a subpoena, um, if it's not somebody that you have a strong relationship with, just abide by the government's request. Um, and I've had clients actually tell the FBI agent or whatever, look, I'm going to tell them about it.
yeah,
And the agent then says, well, we don't think you should, just, because we think they're going to do blah, blah, blah. I say, I don't know that. I
yeah,
just want to tell them about it. I think it's their right to know that their records are being subpoenaed. And
sure,
often that's how we as lawyers find out in these pre-indictment situations that our clients are under investigation because people tell them they've been visited or they've been subpoenaed.
right. Which is very good. Obviously, it's illegal to destroy evidence and so forth, but having that advance notice is very good so that you can lawyer up and line up all your ducks in a row and be prepared and maybe even be proactive where we reach out to them and the law enforcement and say, look, we understand there's an investigation going on and let's open a dialogue here and discuss this. But yeah, I mean, I think you've been pretty clear that the concern from law enforcement, from the investigation side, is if the target of the investigation is alerted to this, it can affect the integrity of the investigation because that target might flee, they might destroy evidence, they might do all sorts of things. And that's what police are trying to avoid because it makes it much easier for them to complete their entire investigation before the target or suspect of their investigation finds out what's going on. And what I've seen, I bet you have too, is on the white collar cases where the client did not get a heads up. They didn't know in advance that the subpoena went out for their bank records, or that some of the employees that they work with had been called in for statements and so forth. And then they actually wind up, they don't know. It's a total surprise when one day they get arrested and they hire us. And now we go through all the evidence with them and we say, oh yeah, there was a subpoena, 7 months ago served on your bank, or your coworker 5 months ago went in and gave a statement. Most of the time, these clients I imagine, again, you've experienced the same thing. They get so mad. Like, I'm been at that bank for 20 years, 30 years. I'm one of their biggest customers. I can't believe they didn't tell me. They they get upset and angry at the bank for not disclosing it. But
Well, it's
you know,
interesting that you mentioned that because I've had a lot of clients who, these are people who are people with great amount of money, and they have strong relationships with their banks. In these cases, with an individual personal banker, and even though the bank will not or may be prohibited from providing that information about the subpoena, their relationship person at the bank will usually tip them off.
yeah,
And the other thing that happens often, and this is a common practice lately, banks will often close your account. I mean, they can't take your money, but they will cease doing business with you. They'll kick you out, so to
that's
speak,
right. Yeah,
when you are under investigation. It's uncanny how many clients I've had who they haven't even been indicted yet, or even when they're indicted, they haven't been convicted yet. Or when they're sued by the SEC, there's been no final determination on the matter. All of a sudden, the bank kicks them out because the bank is afraid they may be involved in money laundering or illegal conduct. Banks right now are running scared for the hills because under the Bank Secrecy Act, they have certain requirements how they're supposed to know their customer and protect themselves. And the government is always making accusations against banks, or often making accusations that they should have known better. So banks are like these scared little kids who, the minute there's any kind of allegation out there, they run for the hills and they kick you out. It's easy for them. And as I said, under those customer service agreements, they don't even have to give you a reason.
that's right. And usually it's very little notice. I've gotten these calls. I get a letter in the mail that you've got, like, 3 business days to move your funds. The account's being
Right.
closed. And it's not like they give you 30 and then what the problem is when you try to move it to a new bank, you may run up against the same wall where they say, nope, we're not going to let you open an account here. I've had clients call me and say, geez, we've tried 3, 4 banks. They won't let me open an account there. And it's a real crisis and a stressful experience for many people that get stuck in this situation. You just said something interesting. And I've been hearing this term so much, like in the last 2 years, know your customer. The term, the abbreviation that KYC. I've been hearing KYC, KYC, KYC. All of a sudden, must have been at like some trade show or seminar where people did a whole talk on know your customer, because KYC is this term I'm hearing all the time now.
I used
And
to think it was KFC, and I thought it was Kentucky Fried Chicken when I
right,
first heard it.
not which is pretty darn good. I think when you get to Florida next week, we're going to do a little KFC run, okay? But yeah, no, it's a real interesting issue with these banks. And by the way, totally side note, just by coincidence, I get a call from a buddy of mine last week. So we're recording today on Friday, but so it was last like Thursday or Friday. And he's like, he's got a really successful business. He's raising some money for it. And he said, Guy, will you get on the phone with me? I've got this guy wanting to put in some money into my company. It was like $21 million investing in the company. And I think I need you to listen to it. Tell me if you think it's kosher. So I get on the call, and they start saying that the money is coming from, I believe they said Africa. And basically, the broker bringing the money is saying, it's the good news here is they're not asking for any equity in your company. They're not asking, it's not set up as a loan. They're basically going to put in about 80 to 100 million in your account, and then you're going to get a fee of 21 million, which is the money my friend's company was trying to raise. And you're going to move the other amount, the balance to these other banks for them, and that's for doing that for them. That's your fee for helping them with banking because they're out of Africa and they want to get to other countries for business purposes, and this and that. And I started thinking to myself, first of all, I asked my client, I put it on mute, and I said to my buddy, I'm like, do you have any idea who this broker is that you've hired? Or he wasn't paying him. The broker was going to make a commission to raise this money for you. He said, no, they were a referral from a referral from a referral. So he had no connection to them. And I basically said, it sure sounds like there's some type of money laundering going on here, or something, funding terrorists, or ammunition and weapons. something is definitely not kosher here. I actually said to the broker, I said, you should be ashamed of yourself and embarrassed for bringing an offer like to my friend here, thinking, that he's going to take it. It's not a loan, it's not equity. He's just going to get a $21 million fee for moving funds around for him. I said, and the fact that if you're really a banker, we know, and Mark, you could probably touch on this, banks have these, circuit breakers now where they pick up on money being moved in and out that doesn't look, that it doesn't look kosher, that something looks fishy and so forth. And that they get an alarm goes off and they look at that count. And when I worked the Jeff Epstein case, there was some questions about that because they felt like some of these deposits that were being made and being paid out quickly, maybe some were, they look at it were they bribes and this and that. So they said the bank should have caught on to that. But anyway, Mark, I don't know your thoughts on, that I'm glad my friend called me in. I told him run. Don't ever work with these guys. Tell them you don't want them looking for money for you anymore. But do you think, my perspective was right on that? The way they were offering $21 million, they were going to put like 80 to 100 in the account and then have my friend wire it out to other.
Yeah, in fact, I have a case I'm going to talk about involving that exact scenario. But
Wow.
it does bring to mind something I think we should do in a future episode, Guy.
Okay.
And that is, we've experienced representing con men and fraudsters. And I think we have great opportunity to tell our listeners about the kind of things to watch out for as a protective device, because the amount of fraud that goes on out there, the ingenuity of people out there who could use that brain power for something positive, but instead uses to rip people off, especially elderly people. It's just outrageous.
Yeah.
And it's incredible the amount of people who are involved in these types of schemes. That particular one you're talking about, absolutely.
Yeah.
That was a con.
Yeah, thank you. I thought you would agree. I will make a note of that in our book of future episode topics because I think you're right. It's a good one. And Mark, I'm sure you'll agree. We'll get a prosecutor on who has expertise in that field,
or an FBI agent or a police officer,
right? Who investigates. Yeah.
So I think you have a good case to talk to us about.
Yeah,
right.
It's a big transition from the topic we just addressed. To talking about.
Well, we like to move around.
Yeah, we do. We do. You more than anyone I know. I think you spend more time on an airplane than in your own bed at home. But so moving around to a violent case, a violent crime, a state crime, and we're going to call my client Michael Jordan, or just Jordan. He's the reason I'm going to call him Michael Jordan. It was not the Michael Jordan, but my client loved basketball and he was actually pretty good at it. And that's really what he did all the time when he wasn't getting himself in trouble. So we'll just call him, to maintain attorney-client privilege and confidentiality, we'll call him Jordan. Now, Jordan was 14 years old. So we all have heard of juvenile court. Juvenile court is where anyone arrested for a crime that's under 18 gets prosecuted in juvenile court. So first, because we really haven't spoken about juvenile court at all, and I know, a lot of people are interested in the distinction between juvenile court and adult court, and, they're not quite sure how juvenile court works. So, and we do like to not only tell our stories, but also educate our audience. So I'm going to take the first few minutes here just to kind of educate on what juvenile court is like and what it's about. And you should know that when I was a prosecutor, I spent about 9 months in the juvenile division. Prosecutors get assigned to a division. You could be in the white-collar division. You could be in major crimes. You could be in drug cases or traffic crimes and so forth. So I was assigned to juvenile. And what's interesting about juvenile is that it was actually the very beginning of my experience as a prosecutor, and it was a great experience because in juvenile court, they don't distinguish between misdemeanor and felony. All crimes, whether it's misdemeanor or felony, go before the judge in juvenile court that you're assigned to. So in other words, when you get to adult court, you have judges who handle the small misdemeanor cases. So you could be assigned to a misdemeanor division as a rookie prosecutor. And after a few years of experience, you then get assigned to a felony division. in front of a felony judge. But if you get assigned as a rookie prosecutor, which I did into juvenile court, it was a huge benefit to me in my career, because right out of the gate, right out of college, out of law school, I started handling serious felonies in juvenile court. In fact, I often think that the most serious felonies come out of juvenile court, which is really kind of scary when you think about it. So anyway, I was a prosecutor in juvenile court, so I understand that system pretty well. And what's another little interesting nugget of information is that not every crime can be prosecuted in juvenile court. If we were in a trivia show, I'd say, or if I was doing something, with a class that I was teaching in law school, like Marc and I have done before on many occasions, I would ask the audience, what crime do you think can't be prosecuted in juvenile court? Well, there's no statute in juvenile court for DUI. Now, why is that? It's because you have to be 21 to drink alcohol in almost every state. I think now it's probably every state. Well, if juvenile only goes up to 18, then it would make no sense that a DUI statute would be applied, or rules of criminal procedure in juvenile court for a DUI, because you shouldn't be under 18 and have a DUI if you can't drink until you're 21. So if you're 15, 16, and I've had these, 17, 18, 19, you're going to be in adult court. And there's a couple other crimes like that, which is interesting. There's no criminal statute in juvenile for certain crimes that you can't be under 18 to commit. So it's interesting. Anyway, so a juvenile, a 15-year-old that gets a DUI is going to adult court. What else can I tell you about that? Oh, there's lots and lots of hearings in juvenile court. Adult court often has a hearing every 30 to 90 days. In federal court, they're fairly, short, 30 to 90 days as well. But in juvenile court, because they're involving children, the judge likes to see that child frequently. I've had cases where the judge literally makes us come back once a week for a hearing, and it can go on for years. Very, very, very time demanding, time consuming. And by the way, the parents need to be there. Can you imagine if your child in juvenile court gets arrested and they're being prosecuted in juvenile court, and you have a job and now you have to take off work? And we all know you don't just show up in court for 10 minutes and leave. You get there, you wait for a long time, your case finally gets called and so forth. It's a big inconvenience. So, of course, the parents aren't the ones being prosecuted, but it's so they're not legally required to be there, but the judge wants them there. Often you'll see no parents because they simply don't care, or they're maybe in jail or disappeared and so forth. But most often you'll see the parents. The judges want the parents there. And occasionally it'll only be one of the two parents because they just simply can't miss so much work. So the reason, of course, they want parents is they want to, it's a child, and they want the parents engaged in the process to hopefully turn this child around, which goes to my next point, is that criminal court for adults is often about punishment. And juvenile court, it used to be also about rehabilitation, but those rehabilitation programs are expensive. And when there were budget cuts, the government got rid of a lot of those rehabilitation programs in adult court. But the rehabilitation still exists very, very strong in juvenile court. So juvenile court is very much focused on rehabilitation and less on a punitive side like it is in adult court. So they like parents there because they want the whole family involved in figuring out what's really going on with this child so we can rehabilitate the child and get them back on track. And they know parents need to be involved in that process. What happens in juvenile court is they have, along the lines of trying to figure out, how do we rehab this child? They do what's called a staffing, where they have government people, they're therapists, they're social workers, they're probation officers, and they meet with the child, they meet with the parents, they can talk to school teachers. They do a very, very thorough background investigation, questioning, testing, gather as much information as they can. It's, again, called a staffing. And then they report back to the prosecutor, to the defense, to the judge, on what they think is the best outcome for this child, the best outcome to get them back on track in life. And unfortunately, sometimes, depending on if the child has history, or if they've criminal history, or if they committed a very serious, heinous, violence, so forth, sophisticated juvenile crime, they'll often recommend at the end of the staffing that they go into a juvenile detention center. And they have different levels, like 1 through 7, with 7 being the most severe lockdown, very, very serious detention center, 1 being the most lenient, usually a shorter term punishment and not lockdown, so forth. But I have found with a lot of these, they're worse than the adult jails and prisons. A lot of times, kids are very scared to go to the juvenile jails. And a lot of times the parents are scared because they know how dangerous it's going to be in there for them. And a whole nother side of it is sometimes you get a really good kid who made a mistake, and we don't want them going to one of these juvenile detention centers because while they're in there, they're going to pick up on things that other kids did. And sometimes the kid comes out of juvenile and they're detention, and they're actually in worse shape than when they went in. So it's not a perfect system, but it is the system we have. And by the way, it can last up to age 21, which is interesting. They can have jurisdiction, juvenile court can have jurisdiction of a child up till their 21st birthday. Typically does end around the age of 18. And the other point I do want to make that people probably don't realize is you don't have a right to a jury trial in juvenile court. Our U.S. Constitution says if you can be punished by incarceration, then you have a right to a jury. So if the potential punishment is going to jail or prison, you can be you have the right to a jury trial, right? Well, in juvenile court, there is no right to a jury trial. So for those of you who are wondering, well, then how do you have a trial? We have what's called a bench trial where there's no jury, there's simply a judge. So you as the defense, the prosecutor, we argue our case and present our witnesses, present our evidence and so forth, just to a judge. And the judge is the one who makes the verdict in juvenile court. So you can look at it a couple different ways. Say, well, let's say you have a jury of 6 in adult court or 12 in adult court and so forth. You've got to convince all of them, whether you're defense or prosecutor, to win your case. You have to have a unanimous verdict as a prosecutor or unanimous as a defense to win your case. One person disagrees, you have a hung jury, you can get a new trial. Well, it's a little different here because you only have one juror, and that's the judge. So prosecutors thinking, I only have to convince one person that this child is guilty. The defense thinks they have to convince one person that your client's not guilty. So it can be a little bit of an interesting analysis and strategy and so forth. And I personally have found a lot of times in juvenile court, judges will err more often on the side of guilty because they feel like that's the only way they can have the opportunity to rehab this child. I have seen cases that were really weak with the lack of evidence and been very surprised by judges' verdicts about finding the child guilty or the juvenile guilty because they felt like this is the best way to get this child some help and some services that the government offers. And the verdict, by the way, is not a conviction like you hear about in adult court. It's actually called being adjudicated delinquent. So there's a little nuance there. You're determined to be delinquent as opposed to having a criminal conviction. I actually wrote an article once that was published probably about 10 years ago and had a lot of publications around the country. It was called "If You Think Your Child's Juvenile Record is Confidential, Think Again." So again, if you think your child's juvenile case is confidential, think again. Because most people think that that juvenile record is not public record, but the truth is that it is a public record. And it was a really important article that I wrote because most parents, if their child gets in trouble, they don't hire a lawyer for them because they think, no big deal. My client and my child will go to court. It's not going to be on their record, and no big deal. But you really do need a lawyer because if it doesn't go well, your child not only could go to one of these delinquent, detention centers, but it's also going to wind up on a record that can be discovered in background checks. And every single college application nowadays has a question. What were you, and you signed under oath that you're answering honestly, were you ever in juvenile court, were you ever determined to be delinquent or not delinquent and so forth. So you got to take these cases seriously. So that's my educational pitch at the moment. And I'm going to talk about Michael Jordan, or Jordan we'll call him, who's 14 years old, not the NBA GOAT that we all know, but a 14-year-old boy who was great at basketball. This is a pretty quick case. It's a serious case though. This young boy, Jordan, He first got arrested. Unfortunately, he was a repeat offender. He got arrested because he was dating a girl, and he broke up with her to date another girl. They're all 14 years old. The girlfriends were jealous of each other, and it was, the typical, unfortunately, teenager, back and forth and jealousy and so forth. But this boy, Jordan, had a very deviant, and he was a little bit of a sick mind at the time, and he convinced his current girlfriend to go beat up his ex-girlfriend, and she did it. She pushed, and he pushed, encouraged, manipulated, persuaded her, and she ultimately followed through to make her boyfriend Jordan happy, and she went and beat up Jordan's ex-girlfriend, and Jordan got arrested for that. There was plenty of evidence to support that case. While that case was pending, I got him into a diversion program, which was not easy to do. The judge was reluctant, the prosecutor was reluctant, but after dozens of hours of court time, everyone finally agreed, we'll put him in a program. He doesn't have to go away. He'll sleep at his own home, but he'll do a bunch of therapy, community service, other things, educational programs. And at the end, after 2 years, if he completes it successfully, no new arrests, the charges will be dropped. He'll have no record in juvenile court. Well, unfortunately, very quickly after entering that program, which was not an easy accomplishment for me to get him in that program, he gets violated on it for posting online a couple photos of him with a gun, and also another one had another weapon, and that was a violation because when you're on, especially as a child, and you're not allowed to have any weapons or guns while you're on these types of programs, on probation and so forth, or in diversion. And so he posts a picture of him with the guns. The prosecutor sees it, gets brought to her attention somehow, and she violates him. It comes back to court. So now he's got the first case, having his girlfriend beat up his ex-girlfriend. Now has a second case, posting a violation for posting guns online. We're trying to resolve these two cases now. Okay. Well, I get him back into diversion, which was another battle. It was a Herculean task. It was, I never thought I'd do it. Somehow I did it. I don't know how to this day. I got convinced the judge to agree to it, but he did. The judge did agree. He did, finally. But now we get a third incident, and this one's the most serious of all. 14 years old still. It all happened in a short period of time. My client, Jordan, gets arrested for serious aggravated serious bodily injury on another 14-year-old girl. And he's accused of using a knife to cut her throat, to cut her abdomen, and cut her on the arm, on the forearm. She survives. She, no serious injury, but permanent scarring. Very, very serious cuts on her. And he's accused of holding her down and physically cutting her with a knife. That he was allegedly had held a lighter to it before he cut her to, sterilize the knife. He was thinking, I don't want her to get an infection from a dirty knife. But this actually winds up coming back to help us in the defense of the case because the case does go to trial. So one more moment of education here is that in juvenile court, even when someone's under 18, the prosecutor has the authority under statute to what they call direct file. They can take a juvenile and put them in adult court. And there's a few reasons. If they're a career criminal in juvenile court, that can give them the legal authority to put them in adult court. Or if the crime is extremely serious with a very serious victim having permanent bodily injury, they can direct file them. They think it's they could direct file them in adult court, or if they think this was a type of crime that an adult-minded person would commit, even though they're a juvenile. So there's some provisions in the statutes that allow a juvenile to be prosecuted in adult court. In this case, because of how violent it was, they moved him to adult court, and they direct filed him instead of in juvenile. They put him in adult. Sometimes it's not the worst thing, because let's say you're a career criminal in juvenile and you get a possession of cocaine, and like, okay, we've had enough of you. You've been in juvenile forever. We're putting you in adult court. Well, that adult court prosecutor, they're used to handling murders and massive Ponzi schemes and grand thefts, and they look at a cocaine case and it's minor. It's nothing. It's not that serious to them. Had that child been in juvenile court, the juvenile prosecutor would look at it as a very, very serious case. So sometimes it can be good to go to felony court. But with these facts that were so serious and left scarring, permanent scarring, it would not have been good in felony court, because then he could have been sentenced for 30 years in prison. And by the way, for this to go to juvenile felony adult court, there is a committee that has to review it, a committee of prosecutors that have to sign off on it. So it's not just something that's haphazardly decided on. They do take it seriously when they move a juvenile to adult court. In this case, the committee did vote to move it to adult court. I worked hard on, I knew it would be better in juvenile, so I worked hard, took about 4 months, but we got the case returned to juvenile court in front of the same judge, who was he's a very good judge. He was a very seasoned judge on juvenile, and I felt like he would be the right one to hear this case out. So the case got returned to juvenile court, and believe it or not, we went to trial on it, and we actually won at trial. So how the heck did we win a trial like this? Well, first of all, the victim had to go on the stand. Now remember, she's 14. I think by the time the trial started, my client and she were in their 15s at this point. We have to be really delicate as defense attorneys when we're dealing with, someone who's young, a child, elderly. We have to be delicate with every witness, of course. We never want to attack a witness. We got to be respectful. But here you're dealing with a 14-year-old, now 15-year-old female who's the victim of a crime. And she's clearly a victim, and we have to show respect for that. But what I had learned during working up the case, I still have to do my job and protect my client, and the government has to do their job and prove that he's guilty beyond a reasonable doubt. So we all have a job to do. So in my hopefully diplomatic, kind, thoughtful, conscientious way, I learned, about the victim's background and her past and some issues she had. And during her testimony, when I got the opportunity to cross-examine her on the stand, I was able to discuss with her some medical and mental issues that she's had, really mental health issues, not medical per se. And it turned out, as I knew going into the direct examination or cross-examination, she was going to admit that she is a cutter. I don't know if our audience, Marc, I don't know if they know about cutters, but there are people who have trichotillomania who pull their hair out. There are people who, have men and women, boys and girls, who have anorexia or bulimia. They starve themselves or they make themselves throw up. There are people who sadly use a knife and cut themselves. It's a psychological condition that many people suffer with, and my heart goes out to them because I know they're living in tremendous pain when they do something like that and scar themselves. I was able, though, in a very genteel way, to get the victim to open up about that, and she did. She was honest, and she spoke very transparently. And she didn't hold back, and I respected that. She was very mature for a 15-year-old. And I then was able to present a witness who was there when this cutting incident occurred. And that witness said that the victim had actually, that both the victim had told this witness and told my client, Jordan, that she was a cutter. The witness said that the witness and my client Jordan knew for months that this young 14-year-old girl, now 15, was a cutter. And they were all hanging out together at the victim's home in her bedroom, and that the victim asked them to cut her, that she asked both of them. In fact, the witness and eventually my client testified that she begged them, that they did not want to do it, but that she said she doesn't get enough satisfaction out of cutting. She wants to take it to another level, and it would help her. And she begged them to cut her. The witness chose not to. She was scared. My client was he was reluctant, didn't want to do it either. He knew it wasn't right. But this young victim was very, very persistent and begged them. She even told them that you take a lighter to the knife. That's how my client knew to take the lighter, to sterilize it, because she didn't want to get an infection. She just, for whatever psychological reasons, she needed to feel the pain of a cut. And unfortunately, my client gave in, and he did cut her. He cut her, as I said at the beginning of this vignette of this case, he cut her on her neck, on her abdomen, and on her arm. And she did. If you know cutters, they typically do not need stitches. Occasionally, when someone cuts, they unfortunately go too deep. Doing it to begin with is very unfortunate and sad, but sometimes a cutter will go too deep and need stitches. In this case, nothing my client did required stitches. And at the end, again, this was a one-person jury. The judge came back and said, well, there was no the victim had asked for it. It was unequivocal that she did ask him to do this, so it wasn't against her will, which is one of the things the government needed to prove. So the judge, in sentencing or in the verdict phase of this trial, this bench trial, this judge trial, not a jury trial, said he said on the record he is extremely concerned about my client's behavior, very disappointed in him, and he's going to address this seriously. But under the law, he has no choice but to make a ruling of not guilty and find my client not guilty. So that's how I got that case found not guilty. However, what we need to remember, as I told you at the beginning, was that Jordan had two other cases. He had the case where he sent the girlfriend to beat up his ex-girlfriend, and he had the case where he violated for posting pictures of himself online with weapons, one which was a couple pictures with a gun. So the judge kind of had the opportunity here to launch my client at sentencing because he got away from, in the judge's perspective, most likely, although of course this was not on the record, but I'm thinking as a human being, that judge who's extremely offended and bothered and disturbed by my client's behavior of cutting this girl, he's like, well, I couldn't find him guilty of that and sentence him on that. But I do have these two other open matters I get to sentence him on. And so I'm going to use that opportunity to really punish this kid and hopefully rehabilitate him. So the sentencing wound up on only those two other matters. And he kind of lit him up. He launched him, as we say in the criminal world. He gave him the maximum level of a juvenile detention center. And my client, the good news is he went in and he did really well. He did so well. Remember, I said, there's jurisdiction up to age 21. In this case, they let him out after 3 years because he completed all sorts of course studies while in detention. He was just a model inmate in the juvenile detention center. And it's now been, so they let him out early, and it's now been 7 years since his case, and he has gotten in no trouble. He actually has a college degree. He holds down a great job. He still lives at home, but I stay in touch with his family, and they say he's doing great. He continued with basketball. He never made it as a professional, probably because he got off track with this very serious case. But he's been able to put his life together. So this is a case where you do see, maybe despite everything, he was rehabilitated. We're 7 years out, and that's a really good sign that he's had no recidivism. And, I just pray and hope, that continues for him in his life. And from what I understand, because it was a small community of kids that were all knew each other. From what I understand, the young girl, the victim, who was 14 at the time, has been doing much better in life. I understand that she went on to graduate school and has completed that. I don't know much more than that, other than that she's, doing very well in life and living apparently a much more healthy, productive situation than she was in back then, which was really sad for everybody. So in a way, a happy ending. I mean, she is permanently scarred, but by the way, because she was a cutter, that was something she had to deal with a lot of other scars that she had self-inflicted. And it sounds to me from what I've heard that she's received a lot of therapy and been able to move past that, which is certainly a blessing for her and her family. And maybe if there's any listeners out there struggling with any type of cutting or a situation like this, that they will reach out and get help, because it's going to take you in, it can take you in a really bad direction, like, criminal behavior, as well as, permanent disfigurement, which is very painful. So Mark, I know there was a big twist from talking about a bank getting a subpoena
Oh,
for
yeah, but
records.
before we do that, because I think I have some questions that only you can answer. I have no experience in the juvenile system, but I think these may be of interest
Sure.
to our listeners. First of all, Are there any statistics? Because you are talking about the purpose of the system, or one of the purposes, main purposes, being rehabilitation. Are there any statistics as to what percentage of people who wind up, kids, juveniles, in the juvenile justice system wind up ultimately being now participants in the adult criminal
Hmm.
system? In other words, how many of them go on to become adult criminals as
Right.
opposed to juvenile criminals?
I haven't seen the statistic, but I talked to my buddies at the prosecutor's office and the public defender's office, and especially one in particular who I started in 1992. I was a prosecutor, he was a public defender. We were in the same courtroom, assigned to a division. He's been in that juvenile division ever since. And he says it's so sad. So they almost all, he says almost all of them wind up in adult court at some point. It's like the recidivism is so high. Again, having not looked at a statistic or researched it, I could ask ChatGPT later, but I bet you anything it's probably 70% or higher. It's a very high number. And a lot of the times you see there's no parents there, and that's often the root of it as well, you know.
Yeah, you wonder, no matter what kind of rehabilitation programs they may have, and as you said, a lot of them been cut um, due to funding issues. Here we get into political situations again,
True.
but notwithstanding whatever is done for them with respect to rehabilitation programs, the end of the day, it's the home life, it's the parenting or lack of parenting that seems to command the future of these
Hmm.
young people,
Yeah.
and that's the sad reality of it.
Yeah.
So the juvenile system winds up, it sounds to me from what you're saying, just the training ground for future
Yeah. And
criminal activity.
it's true. And while the juvenile court does not have jurisdiction over the parents, so they can't order the parents to do a lot of things, but you do see, I'll sit in their courtroom and the judges will reprimand the parents because you can see the parents are setting a horrible example. Child's supposed to have curfew, and yet the child's out after curfew, gets arrested after curfew, and the judge, like, to the parent, he's supposed to be on curfew. Why are you letting him out after curfew? Like, so they do yell, and that's where the Department of Children and Family Services can get involved. The judge can order a DCF investigation, and they put parents on parenting plans and so forth. But a lot of it does come back to the nucleus of the family unit, and if parents are, sometimes doing the best they can, or they have their own struggles in life, it's not a good. It's not a good formula for success for a child to turn their life around. So you can have all these great services, but if the parents are, contrary to the services, they're not being supportive of the services and, enforcing the services, the child's not going to get it. It's very hard for a child to progress in the right direction. It's sad. You said, people should sit in juvenile court for an hour, and it's very sad what you see in there. And when you come from a good family and so forth, it makes you appreciate what you have. Yeah. So,
Well, the numbers are staggering in terms of the cases that come before the courts. The lack of budgetary authorization for programs, the
yep,
overtaxed people who are involved, social workers who are involved in the system,
true.
and it never seems to get better. I know that when I many years ago, I worked as an attorney for a guardian ad litem
Sure, I've done
in
that
these
too.
situations,
Yeah.
and there were cases where the court was, and this was in Florida, in Miami-Dade County, where the court was entertaining terminating parental rights, which is the ultimate
Mm.
death penalty, so to speak,
Right.
in the system. And it's a very sad situation, and it's a very serious option that the courts are very reluctant to take. Sometimes removing the relationship between a parent and child is the only way to save the child.
It's true.
And I personally observed the system working so inefficiently that I wound up getting appointed as a special prosecutor, so to speak,
Hmm.
to actually, in one case, uh, terminate the parental rights, argue for the termination of parental rights. And it was a horrible case involving 5 kids. She kept having kids. There was no fathers involved,
Yeah.
different men. And the children were mistreated. The last incident was a 3-year-old actually found walking across a highway,
Oh,
unsupervised. And uh, even with all of the effort that I made and what I felt was my legal abilities, um, it took forever for the system to work, constantly um, getting continuances and changing judges and new judges not knowing what the case was about. It was an incredibly inefficient system. I hope it's improved, but I
mhm,
got to the point where, in fact, the funny vignette is the foster parents of one of the children who wanted to be able to permanently adopt this child, but it could only happen if the termination of parental rights occurred,
mhm.
sued me, actually made a not sued me,
Oh,
made a bar complaint against me
oh,
because they felt the system was moving too slow. And the
uh-huh,
only way they could get redress is to light a
right,
fire under me. And I didn't need a fire lit under
right.
me. I needed a fire lit under the
Uh,
court. But
Exactly.
I actually had a bar complaint against me
Oh,
because they weren't getting the opportunity to adopt the child because the system was moving so
right.
slowly. Of course, it got
Of
immediately dismissed. It
course.
was ridiculous,
Right.
but it showed the frustration. I didn't take it as personally as I probably should have because I understood the frustration of
Of
that
course.
particular parent,
Yeah.
or foster parent.
Right.
So anyway, Guy,
Yeah.
I think that
Yeah.
the story that I wanted to tell about the scam that my client got embroiled in, that relates to the banking situation. I'm going to save that for another time because
Okay.
it is quite lengthy
I
and I
agree.
wanted to give it its due.
Sure.
So I think unless we have something else,
Yeah.
I think we can kind of
Yeah.
cut it here.
Yeah. The only thing I was gonna say when I mentioned about sitting in court and juvenile, um, you would be amazed at how many kids come through the juvenile court and the cases involve a gun. I'm telling you, if I sit in there for an hour and they bring in 30 different cases, probably 5 of them will involve a juvenile with a gun. It is so, so scary. But anyway, I just had to add that because when I mentioned how incredible it is if you sit in there and see what's really going on, it's scary. So you're
Yeah, I
right.
think everybody actually,
Yeah,
every parent,
right. Should sit in there.
whether you're a good parent
Yeah.
or a lousy parent,
Well,
should
well, you know,
be
there
in
is.
juvenile court to watch.
Yeah, and we do have these programs. If a juvenile does something really, really benign, they'll put them in with a juvenile court program where one of the things they make them do is go watch juvenile court. They're not actually
Hmm.
prosecuted. It's a diversion program. They don't get criminally charged in juvenile court. They get into like a police academy program. They make you sit in the courtroom and see what's going to happen to you if you stay. It's the scared straight approach. So it works with the kids as well as the parents. So sitting in that room and seeing what the reality of what can happen. So anyway,
It's an eye opener.
yep.
Well, kudos to you for working
Thank
and
you.
doing that
Thank
work
you.
in the
Thank you.
system.
I appreciate.
So,
We'll save yours for next time. Put a pin in it.
okay,
All right, my
I
friend.
will.
And we'll see you in
All right.
Florida
So,
very soon.
you bet. So, ladies and gentlemen, as we always sign off, until the next time,
You're
you're free
free
to
to
go.
go. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fronstin and Marc Nurik and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.